Welcome back to the OMB Law Board. I'm Simon Bennett and I've got Sarah from our family law team here at OMB with me today. And we're going to be talking about all things property in respect of family and relationship matters. So Sarah, welcome to your very first time on the OMB Law Board.
Thank you.
We wanted to talk about property today and what that means in the family law context. So could I, get you to give us and our listeners a bit of an understanding of what property is?
Yeah, absolutely. So the Family Law Act very unhelpfully defines it as things that you are or that a party is entitled to, whether in possession or reversion, which for the average person is like, well, what does that mean, right? So there's a few things. There's real property, which includes, your houses, your units, your land, and that includes property overseas. So if you've got a house in New Zealand, for example, you can deal with that. And then there's your personal property, which includes your sort of bank accounts, shares, crypto, that's all included. You have your business. So that's shares in a business or a small business or a large business. And then you have your superannuation, which can be a retail fund or an SMSF. And then you have items like your jewellery, your furniture, your toys, and that includes items that you've been gifted. That's part of the pool.
Right. And then it includes things not just that you own in your personal name, but also through your companies and your trusts and other structures that you may set up throughout your life.
That's right. So, that can trip people up, especially trusts.
So they're all considered personal property, and coming from more a commercial background, in my field, we're setting up companies and trusts and things like that for asset protection or other tax-related strategies, which aren't always seen as personally owned assets. But you guys in the family law field, you just cut straight through all that, don't you?
That's right, and that's something people need to be aware of, that when it comes to your separation or a relationship breakdown, that stuff's not necessarily protected. It does all form part of that pool, and once that's all been valued, then we'll decide how it's separated, but it is all part of the pool.
And is there any exceptions to that, or do you think there's any...
No. So I'm actually from New Zealand, and I find this really interesting because in New Zealand, we do differentiate. Right. We have separate property and we have relationship property. But here in Australia, we don't.
So it all goes into the pool?
It's all in. Yeah.
Right. So once it's in the pool, what we call that the matrimonial property pool?
Yep.
Is that right?
Yep.
And then how do we deal with that? How do we assess what's there and what it's worth and how we're going to, split it up, if you like?
So basically we start with the parties will each generally say what they think's in the pool. And then we have this process called disclosure, which is when you have to disclose to the other party basically what you have. So your bank statements, your evidence of your superannuation, your shares, all those sorts of things so that we can assess what is actually in the pool and if there's things missing. And a note on that is it's really important during a relationship to be aware about what your financials are and what you have and what your partner has. A lot of people take, often one person in the relationship will take a back seat, but when it comes to going through a property separation, that person then doesn't necessarily know what the other person has, and that can cause issues when we come to identify the pool if one party is not being upfront.
So I think that's a really good point. The obligations of disclosure and fair value to the assets is quite important. There's ramifications if one party fails to properly disclose or seeks to hide assets.
That's right. So if you don't disclose the asset and you later then want to include the asset, you can't necessarily, or you can sort of face other punishments. But one of the issues that there is proving it.
Yep.
Proving non-disclosure is really hard, and that's why we say focus on being involved in your financial matters during the relationship rather than trying to find things that you weren't aware of after the relationship. That's much harder.
Now, I just have this thought in my head, please tell me if it's true or not, but a failure by a party to full and frank disclosure and the parties then subsequently reach a binding agreement or a consent order, that the failure by one party to disclose may affect the binding nature of that subsequent agreement. Is that right?
That's right. The other party may be able to apply to have either the orders or the financial agreement set aside.
Wow, that's massive. That is huge. So if you don't disclose and full disclosure, you could lose the protection of your final consent order or your final agreement.
That's right.
That's reason enough to be frank and full in your disclosure, isn't it?
Yep.
Okay, let's talk about valuing it. How do we attribute value to these assets or property?
Yeah, so real property is relatively easy. You generally get a formal valuation, and it's important to understand that appraisals, so if you go and get a real estate agent to do an appraisal, that's not a formal valuation, right? You want to engage a property value company like Acumentus.
Okay.
And then for businesses, that's like a whole nother discussion. There's so many different ways of valuing a business, so we won't go into that today. And then for personal property, you're really looking at what would it sell for on the second-hand market. So if I were to put this on Facebook Marketplace, what are we going to get?
Yep.
So it's not your insurance replacement value. It's not what you paid for it a year ago. It's what would you get second-hand.
And just so that I understand and our listeners can understand, do I get the valuation of my own property? Do you have the right to challenge it? Do we get an independent valuer? How does that system work?
Yeah. So initially you can sort of put values forward, right? One another. So we can try and reach agreement on a value. And then when a value is disputed, that's when we go and look at getting a valuation. Generally for things like real property, the parties will get a joint valuation. So you do need to get a joint valuation, but you'll generally share the cost.
Right.
Unless, for example, if one party's in a much better financial position right now than the other party, they might pay for it in the first instance and be reimbursed a half share when the division is ultimately completed.
Okay, that makes sense.
Yeah.
Now, for matrimonial property or the matrimonial pool, the importance of getting a final consent order or court order or binding financial agreement really sits with me strongly, because there's a problem if I go off and acquire new property after we separate.
Yep.
Is that right?
This comes up all the time. We have so many clients that either don't want to deal with the property division when they separate and they just ignore it, or they do an informal property division with their partner. They might sell the house and each take some sale proceeds and go buy a new property.
Yep.
And that's problematic because the value of property is not taken at the date of separation. It's taken at the date that you resolve your property matters finally and formally, which is by way of consent orders or a binding financial agreement.
Right.
And so you've got to be very careful that you're not going and buying new property, getting into a new relationship and having new bank accounts. That's all going to be part of the pool.
Yep.
So that catches a lot of people out, and people are often very distressed when they find that out, because they might have started a new business. They can't understand why the other party is still entitled to that thing that they've, from their perspective, that the other party hasn't contributed to post-separation. And sometimes we do separate out. We might create two pools to differentiate and identify that the other party has not contributed to this new asset, but usually it forms part of one pool. And even if it were separated into a separate pool, they're still going to have some entitlement to it.
So the big takeaway from that for me is don't postpone getting these things sorted.
Yep.
And fantastic. I'm all for sorting this out amongst yourselves amicably. Fantastic. But if you do, at least come to the OMB family law team to finalise and formalise it for you, so that it doesn't come back and bite you in the bum later.
That's right. Get it sorted. If you've still got a good relationship with the person you've separated from, get an informal agreement together and then come to us, and we can just chuck it in consent orders or chuck it in a binding financial agreement for a much lower cost than if you're in a dispute. But it's so important for your protection to get it finalised. Look, too many people put it off, and I get why they do, but it's a headache. It's a headache for you if you do.
Definitely is. I mean, I know you don't, it's one of those things you may not want to face or deal with, or a lot of people want to avoid the angst.
That's right.
But I think getting it sorted, drawing a line in the sand, if you will, and then being able to move on without looking over your shoulder is very important.
Absolutely.
So, Sarah, thanks so much for coming in and clearing all that up for us. I found that extremely informative, and I'm sure our listeners did as well, and it was great to have you on the podcast. One last question. All Blacks or Wallabies?
All Blacks, of course.
Oh, my God. Thanks for listening, and we'll see you on the next episode of the OMB